Great. I think we can already start. So let me first welcome everyone to this session and thank you very much for being here. My name, first of all, is Agustina Becerra Vázquez. I'm a teaching assistant at the Geneva Academy of International Humanitarian Law and Human Rights. This is the second session of our series Voices from the Ground on accountability for gross human rights violations. This session is entitled, as you know, Transitional Injustice and Human Rights in Nepal. Let me give you a bit of context. For those that were not there in the first session, this is an extracurricular activity in the context of our master programs at the Geneva Academy, the advanced master programs in transitional justice and human rights, the LLM in international humanitarian law and human rights, and the executive master. So the idea of this activity is to allow our students to engage with global experts working in the front lines of justice in various contexts and with people outside the academy so as to enhance the knowledge they get in the master's programs. So today we are discussing about Nepal, transitional justice or injustice, to what extent, justice, injustice, we will discuss this. And we are very honored to have here Salina Kafle. Thank you very much, Salina. Salina is a human rights lawyer in Nepal. She's the executive director at the Human Rights and Justice Center there. This is a nonprofit organization that precisely advances the justice process regarding gross human rights violations committed in the context of the armed conflict. And she has an extensive experience and has observed the transitional justice process in Nepal closely. So thank you very much, Salina, for being here with us.
Thank you for having me.
Thank you. I'm also very pleased to have to be moderating this event with my colleague, Rebas Tremaladze, who is also a teaching assistant at the Geneva Academy in the LLM program in the human rights classes. So thank you, Rebas.
Thank you very much for having me. Thank you.
Thank you. So the dynamic, we only have 1 hour to discuss, to have a conversation, let's say, with Salina. So the dynamic of this session will be the following. With the Rebas, we prepare some questions on key topics about the process, the justice process there, regarding post-conflict, the post-conflict accountability process. And we will post them to Salina for like 45 minutes. And then we will open the floor. We will pick some questions from the chat. So we really encourage you to put your questions there in the chat. We will try to include them in our conversation and post them at the end, depending on the time we have. But please share your questions in the Q&A box. Sorry, not in the chat, but in the Q&A box. So with this, then we will close and we will have 1 hour for our students of discussion with Salina in a separate meeting. With this, I give the floor to Rebas to kick off.
Thank you very much, Agustina. Yes, as I said, it's a pleasure to co-moderate this event with you, and I would like to warmly welcome Salina with us at the Geneva Academy virtually. So in the beginning, before we delve into, let's say, all the transitional justice processes that took place in Nepal, we thought it would be useful to provide a little background and overview to the conflict that took place in Nepal between 1996 and 2006. So a non-international armed conflict that lasted for 10 years. In the lead up to this armed conflict, so we can also provide a little overview of what the situation was before the conflict. And in 1990, Nepal was a constitutional monarchy and a parliamentary democracy. And at the time, the king had lifted a ban on political parties, and the parliament, it was opened to political opponents. But still, at the time, the king maintained considerable and excessive powers. And so it was against this background that there was increasing turmoil. And in 1996, Communist Party of Nepal-Maoists, the CPNM, they declared the People's War in order to establish a communist republic in Nepal, and they fought for the abolition of the constitutional monarchy. And they succeeded in establishing control over a large area of Nepali territory. So what happened during the conflict? Because as we said, it was a non-international armed conflict. International humanitarian law applied together with international human rights law, because Nepal was a party to several of the major international human rights treaties. So serious human rights and international humanitarian law violations are documented by various organs that reported on the conflict, including, for instance, unlawful killings, torture, enforced disappearances, sexual violence, and long-term arbitrary arrests. For instance, International Committee of the Red Cross has stated that 1,300 victims of enforced disappearances are to this day unaccounted for. But in addition to these serious violations, there were also the conflict, like in any armed conflict, it had other types of serious consequences for victims. It resulted in a disruption of government services, health services, and so it exacerbated previous economic difficulties, etc. How the conflict came to a close, parliamentary parties they formed a 7-party alliance in 2006, and so these parliamentary parties, they started negotiating and adopted a letter together with the CPNM. And so finally the new government of Nepal and the CPNM, they signed a comprehensive peace accord in 2006, formally bringing the conflict to a close. And basically this peace accord entailed that truth would be established about the war, and the victims would be provided with justice and reparations, alongside with the proposal to draft a new constitution to demobilize and integrate former Maoist fighters, and to integrate some of the transitional justice processes. So this was the background, and probably also a starting point to a transitional justice process in Nepal. So Salina, if you would like to add anything to the overall background, and perhaps you could tell our listeners, so how did the transitional justice evolve from this point onwards, so after the comprehensive peace accord?
Thank you, Rivas, for putting the background, and thank you, Geneva Academy, for having me here. Like you said, maybe I'll just add a few things before we go into the end of the conflict. Just a few things to highlight about what kind of human rights violations occurred during the conflict. Like you rightly said, that there were several human rights violations, including gross human rights violations, and these were documented by Office of the High Commissioner's report. But and the report said that there were 13,000 people killed, 1,300 disappeared, similar to ICRC's status. But it's believed that the numbers are more than what was documented there, because as we will discuss later about commissions that we have, because when commissions were formed and there was the time to collect the complaints, there were more than 63,000 complaints from all across the country. So the scale of violation still needs to be unfolded, and we will discuss more about Truth and Justice Commission's work on this. But like you said, several reports, including Working Group on Enforced Disappearances, they had a country visit during the conflict, and they have in their report stated that the enforced disappearances were widespread. There were certain areas where they were more prominent than others, like especially in the western side, in a district called Bardia, which was highly targeted area, and it's the district with large inhabitants of indigenous Haru community. So this particular community had more enforced disappearances. Nevertheless, to say that the pattern of violation was similar also around Kathmandu and other, Kathmandu is the capital, also around other places of the country where they were detained, tortured, and then enforcedly disappeared. So there were like similar patterns.
Salina, yes, apologies to interrupt, but perhaps just a small clarification at this point already for our listeners, because it was said, like you correctly highlighted, the scale of violations, the widespread scale of violations, thousands of victims. Were these victims particularly numerous, let's say, in terms of violations committed by one side to the conflict? Was it that both sides committed serious violations of IHL and human rights accordingly? And in particular, I'm asking this because, you know, when we talk about disappearances, and in the Enforced Disappearance Convention, disappearance comes with its specific meaning, you know, it has to be done by a state. So with that in mind, if individuals were deprived of their liberty, their whereabouts unknown, would this, strictly speaking, still be, meaning by the CPN, would this, strictly speaking, still be considered disappearances in this case?
In cases of Nepal, from the reports that we have till now, it seemed that although both parties were involved in serious human rights violations, including enforced disappearances, it seemed that majority of those were conducted by the state officials. I don't know about, there might be a few cases of enforced disappearances by the CPNM, but largely by state officials. What I can say about another serious human rights violation, which is sexual violence during conflict, were also actually largely conducted by the state officials, but there are also reports where they were also victims from the other side, which is CPNM. But on enforced disappearance, not as much as we see in other crimes, but they were violated by both, mostly, as the reports indicate, by the state officials. Now let me go towards the end of conflict, which is 2006 Comprehensive Peace Accord that you rightly said. And it was amazing that Nepal could have this agreement, you know, because to have all the parties in one place and to have it was an achievement of a certain level. We've come a long way from there, but still many things needs to be done. And many prominent human rights activists have played a great role in bringing these all parties in one table of negotiation and having these deliberations and getting it ahead. Like you said, when this comprehensive accord was done, there were three main agendas: that we would have constitution by constituent assembly, which we achieved. We wanted to integrate the Maoist rebels into national army. That was also successful to a certain extent, although there are like some disagreements towards it, but largely it's been accepted by the Nepali society, and there are no problems regarding it. The third and the most important for now is that discussing or dealing with the gross human rights violations that occurred. And when these agreements took place, there was agreement on both sides that they would guarantee not to encourage impunity. There would be establishment of Truth and Reconciliation Commission to take it forward.
Let me jump in there to ask you about this. There was an act in 2014 only. If we think about the conflict ending in 2006, we have the TRC, the Truth Commission Act, in 2014. And as you mentioned, two commissions were created, right? So could you explain us what these commissions were about or are about today, because they are still working? We wanted to know a bit more about that. Yeah.
Yes. So like you rightly said, the conflict ended in 2006, but it took us some years to have this law. It was not that attempts were not made in between this period, because in 2007, the government actually had made public a bill on Truth and Reconciliation Commission. However, when the bill was presented in the parliament, it included various provisions that provided amnesty to serious human rights violations, and which were not acceptable. So all these civil society organizations, victims groups, and human rights activists came against it, and they started advocating that there should be a bill or a law that should not allow amnesty, and there should be other provisions in line with international standards. Somehow there was always demand of having two separate laws to govern these two issues: truth and reconciliation and enforced disappearances. But somehow government decided to have only one law, and then that's how like they proposed this 2000 Act that we have now. And there were like large amnesty, but due to the protest from all sides, there were amendments in 2014 TRC Act than what they actually proposed. However, the 2014 Act also still had concerns about providing amnesty to the serious human rights violations, and there was no guarantee of full consents of the victim required when they wanted to give this amnesty. So this was again challenged by the human rights community and victims group in the Supreme Court of Nepal. And I should say that the Supreme Court of Nepal, especially in cases of transitional justice and gross human rights violations, have played a significant role, because it has pronounced various case laws, including one on enforced disappearance that highlights on Nepal's international standards to investigate, and not to provide amnesty on serious human rights violations. However, the judgment of the Supreme Court came in 26 February 2015, but by then the government had already formed these two commissions. The commissions are Truth and Reconciliation Commission and Commission on the Investigation of Enforced Disappearance, Disappeared People. And these commissions were formed on 10 February, just a few days before the verdict of the Supreme Court. So it was a long battle to say that these commissions were already based on the flawed legislation. So this was iterated in various OHCHR reports and all that. But in 2022, we started again the process of reforming the laws.
And what was the role or the task of these commissions regarding, well, we are mentioning a lot the issue of amnesty. Are they the power to provide amnesty or to recommend it? What were their functions?
When they were initially established, their role was to recommend amnesties. And as we will see, as we'll discuss more into the 2022 efforts on changing the bill and the recent bill of 2022 that passed into law, that these bodies still hold the power to recommend amnesty, which is a great power. And currently we are in the phase of recruiting the members for the committee. And yeah, I think we can discuss more about that on how is it going and what is happening with it.
Great.
But maybe I can, yeah.
Yeah, and I will follow up a bit, just because I was also reading this act, and this amnesty seems not to be a kind of what we call usually blanket amnesty, in the sense that these kind of amnesties that were provided in the past in states like Argentina, post-dictatorship in 1983, where perpetrators grant themselves amnesties without any kind of condition. I saw there were some conditions in law, so I wanted to ask you about that. Were these amnesties granted or not since then?
To explain that, maybe I'd like to focus more on the current legislation that was recently passed and how amnesties work around these issues. So just to give a little background on the current recent bill that we have. In 2022, with the appointment of a new law minister, who was a human rights activist, very much prominent in his area of working around conflict-related cases, there was hope among the victims that now the laws would be framed in line with international standards. But when the negotiations took place, civil society organizations supported it, and there was large-scale negotiations. And we all of us were hopeful. However, when it was time to present the law before the parliament, there were no negotiations with the people who were negotiated previously, So when the law was presented, the final look of the law was not provided to comment upon or reviewed by civil society organization, and it was rather presented to the parliament hastily, and it was very selective negotiations. And then when the bill came out in 2023, it again had very conditions that allowed large amnesties. But with the efforts of the civil society organizations, we've come a long way, and there are certain progressions on this amnesty law. To explain that, I would have to say how crimes are categorized in this new law. In this new law, the crimes are categorized into two different groups. They call it gross human rights violations, and they call it human rights violations. And under gross human rights violations, they have placed things like cruel torture, not just torture, but cruel torture, rape or serious sexual violence, intentional or arbitrary killing, and enforced disappearances. And on human rights violations, there's murder, sexual violence, physical or mental torture, and others. Now, this segregation itself is problematic, first because something like torture is placed not under serious human rights violation, but they've created their own group of crimes, which is a little different than international standards. We know that torture should be absolutely prohibited, but somewhat it is not considered serious, but just human rights violations. In previous iterations of the law was framed somewhat that all these human rights violations would be amnestied, and only the ones that are serious human rights violations could be taken forward for the investigation or prosecution. However, recently with the recent act, there were made some progresses, and now it said that both of these categories can actually be prohibited. But there's so many buts, but it said that these acts should be committed in targeted or planned manner against an unarmed individual or community. So it seems that it has cherry-picked some of the provisions on crime against humanity here and there, but not fully, So Nepal does not, and the bill does not mention anything about crime against humanity or war crime. It just says that amnesty could, it just says that some of the crimes, like let's say torture, can be non-amnestible if it is committed against unarmed person or in a widespread or systematic matter. But it leaves out what can be the role of a public policy in it, or what are the other aspects of crime against humanity. So by doing this, it again seems like there would be only few crimes that would go into prosecution. And another main hurdle is that it sets out these conditions for amnesty, but it is silent on what will happen if the victim will not give its consent for the amnesty. Would it go for prosecution or not? It's silent. So it seems like there are still these gap, and many cases will be left out. Further, the definition of crimes itself are not. It says that we will do it according to prevailing law, but it's not clear which prevailing law. And if we are to suppose that it would be National Penal Code that we have it now, the National Prevailing Code does not give retrospective effect, or it has certain statutory limitation which would not be fulfilling to all these crimes. So I would say that from where it started to give out amnesty to all human rights violations, it has progressed a lot to say that, okay, we'll also incorporate human rights violations. But again, there are so many loopholes and gaps that could be easily maneuvered around not to prosecute these cases. Also, the bill only talks about prosecution, but nothing much about investigations, It gives rights to the members of the commissions to recommend the cases for amnesty, and and also take forward the cases for mediation or reconciliation, but not much about how it would do so. So I think most of the things would also come out by the regulations that commissions will develop in the future, but the foundation still has some loopholes that still exist, because another issue is that it is not. It says that the punishment will be according to the prevailing law, but again, if we are to see that the law we have, and it also says that there will be reduction in the punishment by 75% on serious human rights violations. So the current law we have on torture gives a maximum of 5 years of imprisonment to the perpetrator, and I think around $300 as a fine, which already is less commensurate to the gravity of the crime. Now, if it is to be lowered by 75% and to be imposed on the perpetrators, we also feel that this is not in line with the international standards. Of course, in something like transit,
is in case they contribute to the process, or it's a general decrease for all perpetrators?
Sorry, what is the question?
That decreased penalty in case of torture. I was asking whether this applies to all perpetrators or only to those that participate in the process in the commission and contribute to truth or contribute something. Is this conditioned?
Yes, it is conditioned. It's to only those who come to the commissions, who feel sorry about what they did and apologize to the victims, and all these categories are there.
And this process still didn't happen, or no?
No, not yet. Not yet. It's just a law, and it's just a law. But again, this law is, although it passed through the parliament, initially, few years ago, or even a year and a half ago, even the political parties were not satisfied with the law and it could not pass through the parliament. But now, since it has passed through the parliament, it is a law. But we are at that point in the country where we are still discussing about how to take this forward. So nothing of that has happened yet. It's very recent. It's very recent, and the process of appointing the commissioners just has started, and it is already controversial, and it already seems it's biased. So it has just happened, and nothing has taken action yet. And even the civil society organizations and victims groups agreed to support the country because there are positive provisions in the law as well. Like there are provisions on reparation as a right of the victims. For a country like Nepal, which only believed in compensation in its laws, it's already a big process. So there are positive windows as well. The other positive window is that it promises to open the complaints for the conflict-related sexual violence survivors. And this is crucial for Nepal because of the climate and stigmatization. Many of the women had not been able to lodge their complaints in these commissions. So there are these positive sides, but the civil society organizations, some and victims group agreed to support the country, but we also have reservations that the foundational laws should be amended. So at this moment, we are parallelly taking the support and also reserving some of the provisions in the law, in the new law. And also to say that the 75% reduction is said to be given as it's considered to be binding a request from the Attorney General. So it seems that there will be less role to be played by the judges or the courts on the reduction of the punishment, but it would already be forwarded by the Attorney Generals. And Attorney Generals in Nepal are appointed by the political parties, so that there can be some. It seems like it's also challenging the independency of the courts one, and we don't know how will it assess the proportionality of reducing the sentence, or if it, although it has some criteria on how it would actually work out.
Salina, yes, you highlighted really well some of the, restrictive definitions that are attached to these crimes, let's say, or gross human rights violations. And for example, you pointed to the category of cruel, inhumane torture, which I mean, somehow goes beyond ordinary torture, so not really clear what it entails. But wasn't it also the case that it excludes certain categories of victims? For example, if victims are combatants, I thought I came across that they would not be considered the victims of gross human rights violations, whereas we know very well that, if individuals, for instance, under IHL, they've laid down their arms, or if they're captured, if they're detained, under IHL, they would be entitled to fair treatment once detained. So what would be your thoughts on the exclusion of some categories of victims from the law?
Thank you, Rivas, for pointing this out. I had missed it. That's true that when defining this, it says that it would only be, the people who are only the unarmed people would be considered as victims. So I think this would leave out a big gap, like you said, to the combatants who have maybe given up their arms, or it's. I agree to you to say that it does not incorporate all the principles of international humanitarian law, and it's cherry picked from here and there, not to make a not to give a logical picture of how it would meet with the international standards.
All right. Yes, so then I would like to go back perhaps to the issue you raised about certain categories of victims facing special vulnerabilities and how difficult it's been for them to obtain remedies for the harm that they suffered during the conflict. We came across that this basically fact that the constitutional body, the National Human Rights Commission, in 2020, there was a case of a woman who was subject to sexual violence, and she basically obtained a letter from the National Human Rights Commission saying she was entitled to receive some reparations, and so she tried to pursue different governmental authorities, different governmental bodies, but she wasn't really successful. So I was just wondering how, because there was also this international relief program, if I'm not wrong, initially, and so what was the scope of this relief program? How are reparations obtained, and what hurdles are experienced by certain vulnerable groups of people in obtaining those reparations?
Thank you, Rivas. I'd like to pick on the case that you mentioned, and maybe also give examples of how other victims are suffering from all these ineffectiveness and long processes that we've been taking for so long. The woman that you mentioned was supported by Human Rights and Justice Center, and she was sexually violated during the conflict. When the conflict ended, there were like very less avenues of legal recourse to her, because we also tried to pursue the case before various national courts, but the understanding of the courts was that, oh, but the law, there's no statute. The cases are coming to us that has passed the statute of limitation, which already is very less in the country. And at that time, it was only 35 days for the cases of rape. So although there are very few victims who would be able to reach out to the national authorities, and the ones who would go there would be rejected on the basis of statute of limitation. So the woman actually filed her complaint to the National Human Rights Commission. She also took her case to the Human Rights Committee. There is a decision from the Human Rights Committee to work on it. However, she has not yet received any form of relief until today. There was, like you rightly said, an interim relief program by the government. However, it only provided certain amount of money as interim relief to certain victims. Like there were victims of killings and enforced disappearances who received this amount, but victims of torture and conflict-related sexual violence were excluded as beneficiaries under the relief program, which is why they still don't have received any kind of support yet, and they're leaving one without legal remedies, like I pointed out. Even for the students who might have gone through the report of Human Rights Watch and Advocacy Forum, there are many cases of extrajudicial killings that happened and that were initiated by civil society organizations. But the regular course would be that you approach to the in Nepal police is the primary authority to take the complaint, so they would outrightly reject it, or if they register it, they would not begin the investigation. And if the other legal recourse that Nepal can adopt to take the cases before courts, there would be directions from the courts, but the Nepal police still would not investigate it. And some of them would also say that, oh, but we are directed from the Ministry of Home Affairs not to take these cases forward, So not much have happened. Maybe some of the victims have received interim relief, but however, no forms of holistic reparation as such has been given in the past. We are hopeful towards this at this point of time that the new bill might work, at least on the reparation sides, because at least on that side, the government looks promising and it has made efforts. It has brought positive changes on that side. But there are many victims like child soldiers who government really does not deal much with. And there are many victims who are living with bullets on their bodies, many victims who are living with prosthetics and they don't have money to change it, or many of them like living on diapers because they are paralyzed below the waist, you know. So the situation is really difficult, not only in that terms, also in social terms where they are ostracized from the community and they're looked down. So yeah, but hopefully there might be some work on reparation.
All right. And Salina, I would like to ask you concerning another vulnerable group of victims, especially as well, perhaps their family members. And it concerns the people that have been forcibly disappeared. And also we are aware that in 2007, you highlighted basically positive involvement of the Supreme Court of Nepal in the transitional justice process. And there was a decision in relation to habeas corpus petitions, and the Supreme Court, recommended that enforced disappearance should be criminalized. They even called for the establishment of the Commission of Inquiry, and that compensation would be provided to victims' families. So what is the work done with respect to disappearances to this point, and would you say that it's adequate, or how can it be improved?
The commissions were established in 2015, like I mentioned, and however, they had been the commissioners and the members were changed. Like there were two different terms of the commissioners and members. The commissions were initially formed for a certain time, but the time kept on extending because they were not able to work for the victims. Mainly their failure was their independence. They were more politically inclined. They did not have their independence. Many of the commissioner members and the staff of these commissions also complained that they did not have resources that they required. However, it's also believed that there was not, since the main objection to the members of the commission was their appointment itself, because the victims did not want to engage with commissions where commissioners and members were politically influenced and were more appointed because their affiliation towards political parties, which is why after the new bill in 2024, there was much discussion about how to elect these commissioners and members. The main question was surrounding under this. And there was a committee formed under the leadership of a former Chief Justice. There were other human rights activists and members of the national human rights institutions in the committee to select the members. And all of the victims considered that the process should be transparent, it should include victims, and it was somewhat taking that track that it publicly called for the applications, whoever wants to become commissioners and members. However, 3 days ago, when the list of people was released by the Ministry of Law on the basis of the applications they received, there's already some kind of disappointment in victims and victims groups. 28 victim groups and organizations have released a press note saying that they again think the list released by the government has people who are politically biased and they're against the selection process, and they want the government to reformulate the process and publish the list, because when the applications were open, many victims also referred the human rights activists and people who have been working on around this area, but they were not all of them. There are some good people in the list, but not all of them were accommodated in the list, and there are resentment against it. And in general, I think the work of commissions in Nepal, like you mentioned in the beginning, that before we had the war, we had people's movement in the country, and we had commissions established in the country, not particularly transitional justice, but commissions to investigate around the violations that took place during the revolutions. However, every time we have had the reports, either the reports were not made public or the reports were never implemented. So this whole system of unaccountability is high in Nepal, not just in terms of law, but in terms of how to go forward with the commission's reports as well. So if we are to achieve with this transitional justice mechanisms, we should be looking forward not to repeat it in the future, but it seems like we've not really learned from our past yet.
I pick up from there and link this also with one of the questions in the chat to close this part before opening for more questions, which is in view of the last reform. There, you already mentioned the last reform or amendment to the 2014 Act was this adopted this year. So you mentioned already some problems and also some progress at the same time of this act. So we wanted to ask you if you are hopeful about the changes of this new bill, or what things could be or should be improved. And the question in the chat is precisely about the lesson learned, which you just mentioned, that should be integrated to improve, for instance, reparation for survivors or justice in general.
I think there are many things that we can learn from the past failures of the commissions, because when commissions worked, they did a few things like really like working on the identity card of the victims and getting the complaints from the people, but never really worked towards it. There were also some news that they'll also try to work on the exhumation of the mass graves, but nothing public or nothing concrete of such ever evolved into practice or was not public. So maybe if this commission, I think the first thing that Nepal should learn would be a proper list of commissioners, because these commissioners have a lot of responsibility on them. They have various rights regarding recommendations to make. So the commissioners and the members should be appointed in transparency, and it should be approved by the victims community at least. So I think the first step would be what 3 days ago was done wrong. I think it can start from there. But like I said, I think also the commissions can already start working on the emblematic cases they have, because there are some emblematic cases that have somewhat reached to the courts, but never yet yielded into something fruitful, reached out to Human Rights Committee and other international avenues. So I think in the past, the commission worked more towards only collecting the complaints, but never really worked into one of those. So maybe they can already start working in emblematic cases. And I think the other challenge would be on getting evidences, because if we really want these cases to move forward, there should be guarantee that there should be solid evidences. And we know that for some serious human rights violations, it needs a solid, strong basis of evidences. So maybe work around those. And one of the other areas where evidences really becomes prominent is conflict-related sexual violence survivors. And although Nepal adopted a national action policy on it, it somewhat got trickier when it was time to locate who the victims were. And it was difficult, one, because they don't want to get identified as victims. So I think civil society organizations and human rights activists are working towards it, and more needs to be done on that side, and also to consider what might be possible evidences for the crimes of rape and serious human rights, serious sexual violence, for which there is no amnesty. But it seems like there's much to be done in evidence regarding all the crimes, but especially CRSP, enforced disappearances, and others as well. And I think everything should go in coordination with each other. The nature of the crimes, the nature of the conflict, the root causes of the conflict were never earlier studied on. So the commissions can also work towards all these things, I feel. And just to add a last point, that it should also look into the into different nature of conflict, like I said, but also nature of victims, because indigenous communities and Dalit communities, certain communities were more marginalized than others. So I think it should also look into this different kinds of victims when it would work in the future.
Thank you, Salina. And now I'm going to take you a little bit farther into the past, because this time the question, a very interesting question, which though relates to the beginning of the transitional justice process. And in particular, the question asks about negotiations at the end of the conflict, in particular, who the actors were and whether international actors were also involved, international organizations and non-governmental ones, and whether it is necessary or useful to have international regional actors involved in the drafting of peace agreements like this one.
Like I mentioned, that there were three main agendas that were promised during the end of the conflict in comprehensive peace accord. The constitution framing was done by the national actors. The second point of integrating the rebels into the national army was done with the support of a special mission by the UN. So there was a special mission created by the UN, which came to Nepal and which actually supported in this integration of the people. And regarding the and those two were there, but regarding gross human rights violations, I think it's been mostly national actors. But saying that, I think. But the good part was that all these actions of Nepali people were time and again monitored by several international actors. So I have to say that the embassies who were in Nepal, also the OHCHR, various units of treaty bodies like Human Rights Committee, time and again had given their reports concluding, it was included in concluding observations in various decisions. So I think monitoring in that aspect was done. But if we are to carry on it forward, I think it would be great to have an international actor that help Nepal do all this. There was an OHCHR office in Nepal some years ago, but then the government didn't want to take the mandate of the OHCHR forward, and it said like, okay, we'll solve our all issues Nepali way. The Nepali way still is under covering. I don't know I don't know if cruel torture would not be a serious human rights violation is the Nepali way, you know. But then there was a presence of OHCHR to a certain point of time, but then it was closed. It was not extended by the government. But I think in the future, it would of course be good to have some international support, especially when we're discussing about all these violations that happened in the conflict.
All right. Yes. So thank you very much. You mentioned this whole unaccountability, basically how, criminal complaints are brought, but sometimes the police, they will say government is blocking us to take further action in respect of these criminal complaints. And the information that I came across mentioned that the Advocacy Forum Nepal, it brought around 62 cases about conflict era extrajudicial killings before Nepali courts. However, again, the further action was blocked by the government. Although there was this one case in which in 2017, the Kavre District Court sentenced 3 officials to life imprisonment for the murder of a 15-year-old Maina Sunuwar. Who was in army custody in February 2004. The arrest warrant was delivered as well. But perhaps, Salina, you could once again explain for us and our listeners about this surrounding unaccountability in the process, what is causing it, and what should be done in your view.
Mm-hmm. Like you've put that, and like we say that when the injustices of the past are not addressed, it keeps on stretching towards the future as well, because even after the end of the conflict, there are cases of torture, there are cases of extrajudicial killings in the name of encounter murders, which never get passed through, because we have not set a standard. Many of the cases go through the same process that these 62 extrajudicial killings went through, that they're never either not registered or not taken forward for the investigation. The particular case of Maina Sunwar, as I know, was really pushed forward by Advocacy Forum, and they worked really hard on the case. There were multiple threats of what I know that came towards their side, especially from one of the parties of one of the state organs, let's call it that way, and they had to fight a lot. So there was this decision, however, to my knowledge, that the perpetrators were still considered to be absconding and they were not behind the bars. So it seems like, the whole accountability regime in Nepal is absent. All it wants to, even the government only wants to work towards reparations, but prosecution, accountability, no.
And Salina, would you think that this lack of accountability for conflict era crimes and let's say past crimes that occurred during the armed conflict, do you see it as somehow aggravating sort of impunity, or for instance, that it extends beyond conflict, and it's even today, let's say, if there are, let's say, police misconduct or human rights violations against persons in custody, are such cases investigated, or is that part of sort of that wider picture of lack of accountability?
Statistically, there of course are lesser torture crimes than what happened during the conflict, because there was like large scale, widespread, systematic at that time. So statistically, we don't have as many cases of torture that we used to have in the past. But the problem of accountability is the same. I think very, very, very less cases actually reach out to the formal mechanisms. Otherwise, I think there's also this there's no concept among people and no trust of people towards the public institutions that it will take our cases forward. If a person is killed, let's say in the southern belt of the country, extrajudicially, the family would have to be convinced or like legally be aware to say that you can take a case forward. There's no concept that, among them, that they can actually bring a case against it. So I would say that the knowledge is also absent to a greater level, but also because these cases, whenever they reach out to the police stations, they're either sorted out between themselves or dismissed, or state that these do not fall under their criteria as such. So in terms of application of in terms of dealing with accountability, it's highly absent in torture, extrajudicial killings, or other serious human rights violations, even today.
I see. And perhaps to go back to another point that you mentioned earlier, and going also beyond criminal measures and criminal sanctions, because you highlighted how some victims, even today, they're suffering from physical as well as psychological trauma, that they require medical treatment and counseling. And so do you think that there is something that a state needs to do in that direction as well? I mean, going beyond, let's say, criminal sanctions and adopting wider measures to deal with those?
Yes, of course. I think that a part of reparation also would be to heal and provide these victims with the essentials to live their everyday life, because the everyday life is also difficult for them. So I feel that to a certain extent, many civil society organizations and also local governments, because we initially at the start of the war, we didn't have a federal system, but with the new constitution in 2015, we have a federal system, and there are local governments that are working close to the victims, and they know victims. Some of them were victims themselves, the representatives of local government. So I know that many of them have also worked towards providing these medical supplies to the victims and as such, but there is not a uniform policy across the country on reparation. So these are rather haphazard. Some of them are doing it, some not, but there have been some work on this by the local governments, civil society organizations as well, but of course more could be done. I agree, even on memorialization as such. But I think I missed something, and something that we can discuss further with the students as well is that about the question on support of the international community. I think it's also good to see on the real context of Nepal to actually to understand the real context to deal with these situations, because nowadays there were many discussions about South African model and then Colombian model and Sierra Leone, but I think we can also work more towards understanding these models, and if yes, what could be really inspired from these models to adapt and not like completely take over, like completely duplicate the models, but to understand our society better. So I think that there's also work of sociologists, anthropologists, everyone actually, since TJ's legal, political, social, it requires all these dimensions. I think all these dimensions should be dealt with.
Thank you very much, Salina, for this insightful and very complete and comprehensive dialogue. I would continue asking more things, but we are almost on time, and we will now continue discussing with our students. So I really thank you for being here, for joining us for this public event, to Rebas for moderating with me, and to everyone who is here who stayed this hour. You have our contacts in the Geneva Academy website. Also, if you want to contact us with more questions or issues, we would be open to that. So we can, I think, close here. And then thank you very much. And next events of the Academy will be posted in the networks. Thank you.
Thank you. Thank you, everyone.